Ken was a 1971 alum of our department, went on to MIT to get a master's degree in EE, and then went to Northeastern for law school. And since that time has made his home in Palo Alto, California, in the heart of Silicon Valley, at Kilpatrick, Townsend, and Stockton, which is a well-known firm in Palo Alto. Does a lot of Ken does a lot of Silicon Valley patent and IP work. So I appreciate Ken coming out and taking the time to talk to you guys today. Hope you enjoy the pizza. Without further ado,
Thank you. How many of you here are inventors?
They're all inventors.
You're all inventors. You're all inventors. The only issue is whether you invent patentable inventions. But whatever you do is an invention. I call invention the process of reducing entropy. The first thing I want you to know about your careers is that the professors are not always right.
Hey.
As an undergraduate, you learn answers to questions. As a graduate student, you learn that there are questions to be answered. And in fact, you get your degree because you have answered questions that have never been answered before. But as a lawyer, you learn to question every answer. When I was a graduate student at MIT working on lasers, I asked a prominent Kodak scientist about the need for triplet quenching. I asked him whether glycol would work as a triplet quencher, and he said, no, you had to use a surfactant, a soap or something. So he didn't know that I'd already used glycol in my laser. I was building CW dye lasers, and it had worked. And in fact, we were able to build a CW dye laser flowing glycol with rhodamine 6G in it in such a way that we had laminar flow. And we were able to achieve a laser with a Q of several million, with like a 50 kilohertz bandwidth, if you can imagine a laser with that thin of a line. And it was tunable. We could tune it for a couple of octaves by some tricks of mechanics. But that was one of my lessons that I learned, that professors don't know everything. So learn to challenge authority if you want to master your profession. What you can do in challenging is question them in a nice way so that they think about the problem. Because if you're going to be an inventor, you really do have to question authority because you're usually making a departure from what's gone before. One of the grounds of rejection of a patent, for example, is that it is mere engineering design choice. An invention, hopefully, is not a mere engineering design choice. It's a novel action which is non-obvious. The other point I wanted to make here, before I really get into a discussion of career opportunities, is the fact that you as engineering students and technologists have a career half-life. That career half-life is only about 7 years. So it's time to start thinking about what you're going to do at the end of the, say, 15-year term of your engineering career. And because there is such a premium on experience in the fields that I went into, you can still think about such things as patent law, law school, start thinking ahead now. There are other ways to do that. Yes?
Would you say that if you go to law school, your half-life is longer?
The half-life is nearly infinite because you can make your own way. So if you want to stay in technology, you have to keep up with technology or go into management of technology or run your own business. One of the things, if you haven't learned it already, is that you may be able to get a job with a BS, but you might want to go on to graduate school as soon as you feel comfortable with doing so. And there are lots of opportunities around here, so think about that. To prove my point, when I talked about a half-life for engineers, Steve Siri, who's a management consultant, published a blog in August, and he asked, does Moore's Law apply to engineers? And he said, absolutely. And he describes how your technical knowledge becomes obsolete fairly quickly, depending on what technology you're in. I mean, if you want to spend your life taking care of a piece of equipment, you can do so until that equipment dies. But again, that's a limiting factor on your career. So what are some of the things that you can do after engineering? You can do law, you can do business, you can do sales, you can even do river rafting. We went rafting down the Grand Canyon a couple of months ago, and one of our guides was a former engineer. So he was having a great time. People ask me, why did I leave engineering? And the answer is, I didn't leave engineering. I chose patent law so I could stay close to engineering and get people to pay me to learn. I would recommend to you a book by an LDS guru professor at Harvard Business School. Have any of you heard of Clayton Christensen? Clayton Christensen wrote a book that is great for career planning and just kind of self-evaluation called How Will You Measure Your Life? Get it on Amazon or go buy it at the BYU bookstore. How Will You Measure Your Life by Clayton Christensen. And he talks about the whole problem of knowing what your career is about. I got a very first-hand lesson for that when I was working as a summer student while I was here at BYU. I was invited to work at Hewlett-Packard Santa Clara Division, Frequency and Time. And the project leader was a Mormon bishop. And he sat me down and said, I want you to think about what your career will be and I want you to plan it out. And he said, set some goals, make them achievable, and set yourself a timeline because you don't want to end up just spinning your wheels. A couple of tools that you want to learn as an engineer. Learn PowerPoint and learn Excel. And when I taught this class about 30 years ago, and I did come here about 30 years ago and talk to engineers here at the school, I told them they should learn how to type. Now, you grew up typing, you grew up keyboarding, but now you need to master those other tools. Also learn to write persuasively. I also want to share with you what happened to one of the missionaries that came to visit me about 12 years ago. He's a BYU student who'd come out to the Bay Area to be a missionary. He was directed to work with the Chinese-speaking potential converts and others in the Bay Area. And he asked me at dinner one evening about my career and why I chose it and what it would take to become a patent lawyer. And so I outlined it. I said, well, you need to get a degree in engineering. If possible, get at least a master's. PhD would also be helpful. But do some graduate work so you get a feel for what the technology state-of-the-art is at the time you graduate. Then choose a good law school, the best you can get into. Network with them, study for the patent bar, pass the patent bar before you graduate from law school. Try to clerk with a company or a firm that has a department where you can be tutored in patent law, learn how to write patent applications, and pass the patent bar before you graduate. 10 years later, I got a telephone call, and he says, you may not remember me. My name is Ryan Sydenham. I came to dinner at your house 10 years ago, and your firm just hired me to be a patent lawyer. I think the advice works. Let me tell you a little about my firm. We have offices around the world. Our West Coast offices, Walnut Creek, San Francisco, Silicon Valley, and San Diego, and Walnut Creek, also Denver, are the legacy Townsend & Townsend offices. Townsend is sort of a brand name in patents. The East Coast offices were the Kilpatrick Stockton offices. Those East Coast offices has a very strong IP practice in what we would call commercial IP. Trademarks, a lot of litigation. So there's a marriage between the high-tech nerds of the West Coast and the commercial trademark people and litigators of the East Coast. And so we've been together about 3 years, and it seems to be working out. We're like fifth largest IP practices in the U.S., and we have just about 300 of our 650 lawyers who are devoted to IP in some way, and of those, 200 are patent lawyers. And so this gives you an idea of what our practice is. It's not a general practice firm, it's a multiple specialty firm. And so we work with business and finance, we have IP in all stages, we do litigation, we do technology transactions, we do labor employment, we do health and life sciences in the IP side as well as electronics and computer science. Let me talk a little about some of the careers that you could pursue in law, not just as a lawyer. But what is the most obvious career choice for someone with a technology background in a law firm? It's IT support. Now, it's something that is probably far beyond what your interests are. You can go get somebody out of the computer science department to do that. But IT support is critical to the operation of a law firm these days. We have 650 lawyers, another 700 or 800 staff members. Almost all of them have access to a computer or a computer on their desk. And by a ratio of 50 to 1, we have that many technologists who are doing IT support around the world. And they have to be on call 24/7. When I started my career with a correcting selectric writing patent applications, it would take me 2 weeks to respond to any letter query of a client. Now, in the last 20 minutes, I've gotten emails from a half a dozen clients asking me to respond, thanks to the power of a supercomputer in a smartphone. One of the things that occurred during the course of my career related to Moore's Law is not only the density of semiconductor silicon transistors, but the cost. In 1984, I wrote a letter to a client saying someday memory will cost less than $4,000 a megabyte. All right, some of the opportunities in IP prosecution paralegal. These are people who are the administrators of a patent practice. They provide administrative support to the patent attorneys, and they do a lot of form preparation, they maintain the dockets, and they actually do the communications with the clients. In the legal administrator, probably of less interest to you, but are some of these operations, practice management, marketing, facilities management, and as engineers, you may have to understand that you need to be salesmen. You have to sell what you can do to other people. That's one of the skills that you'll need to develop, not just to master the technology. And finally, there's the practice of being a patent attorney. And these are the sorts of things that we do. Counseling, where every time a client comes in, we have to give them some idea of what the scope of their work will be, what their opportunities are to protect it. Often we can give them business advice. Opinion preparation, when someone comes to us and they say, somebody has told us that we're infringing a patent, it's the lawyer's job to look at that patent, compare it to the prior art, and render a legally supportable opinion as to whether they are infringing. Now, just as a matter of course, a patent attorney is never going to tell a client in writing that they're infringing someone else's patent. They may call them up on the telephone and say, we need to talk. I'm not going to write an opinion, but you're going to pay a lot of money to hear this very bad advice. Or you're going to pay more money if you ignore it. But we try to write our opinions in such a way as the client can rely on them and avoid a charge of infringement. Of course, that fails, we end up doing litigation. Advocacy is an important role. That's sort of the glory. If you've watched any of the lawyer TV shows, all you see is the advocacy. You don't see the people sitting in their offices telling people what they can do. A lot of what lawyers do, which is really boring but very important and probably the bread and butter of what you do, is document preparation. Document preparation includes writing patent applications, which means you take a written disclosure from sometimes barely literate second language engineers and try to turn it into something that's a persuasive document that will persuade an examiner to grant a patent. The document preparation also includes preparing responses to what are called office actions. Office actions are what the patent office issues after an examination, giving reasons why the patent application doesn't describe a patentable invention. And that document preparation includes arguments, amendments to the claims, and any other documents that may relate to it, which are called IDSs, information disclosure statements, in which you disclose to the patent office under your obligation to tell the patent office any of the relevant prior art that exists about this invention. Mediation. Often you're put in a position where you're going to have to convince two opposing sides what they should do to each other or not do to each other. You're often the only adult in the room, and you will need to exercise a certain amount of patience. Negotiations, kind of an extension of mediation, although you're doing it on one side or the other, representing a party in a negotiation. Transactions, where you're often preparing licenses or working out licensing terms. That's typically something that is incorporated into in-house legal department because they're transactions of all kinds. Contracts, not just licenses of IP, are an important part of business. Client Affairs Administration. When you have a patent portfolio of several thousand items, you need to be able to keep track of that. Our firm uses a third-party database to maintain records on the patent portfolio of our clients, and the largest third-party supplier of this computer program database management system is called Foundation IP. They reported to us that our firm has the largest database patent docket in the world, and our database represented twice as much as all of the other patent clients that they have. So that kind of surprised us that we were that large. And of course, you're going to be either mentored or do mentoring for others. because a career in patent law requires that you be constantly educated so that you can keep up with the technology as well as career opportunities. Legal research and technical research is often one of the things that is most interesting. This includes analysis of prior art. A good patent attorney could look at a patent claim set and tell you why a claim was allowed just by looking at the language. That sort of analysis is very valuable because it allows the attorney to focus on what the client needs to avoid infringement. And it's just basically a very interesting problem-solving career. These other things, they're not the day-to-day work except for the administration. There is administration in managing other attorneys. Lawyers, by their nature, are not necessarily good managers. They teach seminars to lawyers on how to be good managers, but I think lawyers become lawyers because they don't want to become managers. Also, administrating a bunch of cats is also very difficult, and leading lawyers is kind of like herding cats. There are non-firm government jobs, voluntary part-time, early, E&E stands for early neutral evaluation, and there's arbitration. All of these are careers that are quasi-judicial or judicial in nature, where your knowledge of technology becomes a valuable asset in making judgments. Typically, those are the more senior attorneys. I serve as a judge pro tem. The requirement would be that I have 10 years experience and go through a series of courses in law school. We study for the bar. Well, the courses that I took to train to become a judge pro tem was basically a review of all of the coursework that I'd taken in law school and in preparation for the law exam. I sit in the Superior Court of Santa Clara County in the Small Claims Division. In other words, you're looking at a Judge Judy here. Any questions to this point? Well, I promised to tell you some war stories. Yes?
What kind of engineer, like what personality attributes would you see in like somebody who would enjoy a career as an IP lawyer?
You need to be a person who is comfortable with an incredible amount of attention to detail. If you don't have attention to detail in legal career, and probably in engineering too, you're not going to succeed. There's a lot of detail. A typo can make a difference. And it's pretty boring. You just sit there as a patent prosecutor, working all day, reviewing documents, rewriting documents, analyzing technology, answering the telephone, answering emails, deleting spam. And so it does require some patience and good attention to detail. Now, that's one level. At another level, you're really kind of a salesman, an advocate. You can get out and talk to people. If you enjoy talking to people, that's fine. That's very useful. But patent attorneys are the propeller heads of the law. There are lawyers out there who can't hang a picture without hiring somebody. I assume that none of you have two left thumbs. You wouldn't be in engineering, and particularly hardware-oriented engineers, unless you had some mechanical aptitude. Someone asked me once what I did for relief from doing all of this mental stuff. And I said, well, I took a welding class and I rebuilt a Porsche. So that was psychological relief to the stress of dealing every day with just documents. Does that answer your question? There are various levels of engineering. They can put you in the dark and feed you fertilizer and things will grow like mushrooms. That was the Hewlett-Packard philosophy. They didn't really tell you what you were supposed to be doing. You were just supposed to do this narrow task. I was working at HP during the time when Rick Perring was doing all the software for the HP 35 calculator. It was a secret project, and I was working on some other project and had no idea what this guy was doing. There was just very narrowly focused, and it wasn't communicated. In each instance, the attention to detail is important. Certainly, likely in a lot of engineering, design engineering, and particularly in a non-union shop, you'll have a lot of opportunities to get hands-on on circuitry and processes. But a lot of engineers end up in union shops, and they're not even allowed to touch the equipment that they're responsible for, the product they're responsible for. My son is an industrial engineering graduate. He went to work for Lockheed. He was responsible for a machine which filled the wings of the F-35 fighter with foam. He was not allowed to touch it. All he could do was prepare presentations and design reliability design charts for his project to make sure it got done right. I mean, That was frustrating enough to him that he quit engineering, and he's now doing a graduate degree in communications here at BYU. So, any other questions? Yes?
Speaking a little bit of graduate work, like, is it preferable to do graduate work, say, within engineering, or can you branch out into other areas, say, like business, or I guess in your son's case, like
That's a great question, and it really depends on your aptitude and your interests. And if you're going into patent law, you need to have a level of education which will allow you to speak at a peer level with inventors. We have people who we have hired are MD, PhDs. So they have an MD, a PhD in either engineering or science, and they're also lawyers. We also have PhD MBAs and JDs that we hire. And so if you have an MD, PhD, JD, MBA, we're going to look at you very seriously. But it depends a great deal on what your interests and aptitudes are. MBA is very helpful for learning management skills, learning how to read a balance sheet. It's not so helpful in writing patent applications. It's certainly a graduate degree. I was telling Brent, my favorite associate is actually he's now a partner, has a PhD in biomathematics. It's a crossover field. Crossover fields are where the inventions, the most fruitful inventions are now. So much of Silicon Valley is devoted to software right now that it's kind of being burned out as far as innovation is concerned. So social networking is very popular, but I see it as eventually fading. There'll be a few big winners like Google, but if you look at what Google's doing, it's doing a lot of engineering too. And then one of my big clients is Complete Genomics, which does the fastest genome sequencing in the world. And that took imaging engineers, biochemists, biomathematicians, all of them PhDs, to develop the technology to operate chemical reactions and observations at very high speed and very high density. If you get a good cross-section, a good interdisciplinary exposure, and you're interested in patent law, you'll be well received. And other question?
Yeah, what would be the marginal benefit of a PhD over a master's degree for someone wanting to pursue it?
It really depends on your field. If you were in the life sciences, you practically need a PhD to become a patent lawyer. Almost all of our health and life science patent lawyers have PhDs. Less so in the mechanical areas and in electrical and computer science. Experience counts for a lot. And a lot of the master's programs, particularly where I went at MIT, a master's program was a consolation prize on your way to a PhD. But I was not interested in getting a PhD, so I took all the courses to get a PhD, but I didn't write a dissertation. That's kind of what you get. You get all the coursework for a PhD if you get a good master's. There are very few courses past a master's for a PhD, except if you're working in an area where you need some specialty training for your dissertation. On my way to getting my master's at MIT, I sat in and audited, without credit, a lot of other courses that I was interested in. So I learned everything I could about Bayesian statistics, for example, and estimation theory. Well, I did my credit courses in digital signal processing and circuit design and lasers.
Can I interject something, and maybe you can correct me if I'm wrong, but I mean, one of the advantages of doing a PhD is where I first started interfacing with IP lawyers and patent lawyers, because I filed some patents that still pay me royalties while I was a PhD. And so the experience of going through it sometimes, I mean, having that experience of having been on the other side of a patent lawyer, my guess is that lends itself well to becoming a patent lawyer.
If you're working on a PhD, you're generally working in an area where there's a lot of potential patentable inventions. In fact, all of my classmates at MIT who were working on PhDs went on to found companies. And that's one way to avoid having to go into law school. Just to give you one of the real disadvantages of going to law school is it'll probably ruin your sight. You're going to be reading so much material that you're going to burn out your eyes.
So you mentioned earlier you want to get into the best law school you can. So I heard from a BYU law school alumnus that if he could go back, he would rather go to a law school that was ranked higher, even if it was a lot more expensive, just because he felt that was more meaningful. And that you shouldn't worry about price, you should just worry about about rank when it comes to law school?
You know, there's some merit to that. I think BYU is ranked lower than it should be. BYU does have excellent professors, and you've got some really terrific lawyers coming out of BYU Law School. My observation is that the best, and this is true of all schools, the best students at any school are comparable. The top students at MIT are comparable to the top students at BYU. The difference is everybody at MIT is a top student. One of my friends at MIT who went on to get a PhD and is now on the faculty there thought he was really hot stuff. He went to MIT with a perfect 800 on his SAT. That was a perfect score in the math. He got there, he found out that half the students who were entering freshmen had 800s on their math. But you can get a good education here, and any school has its specialties in graduate work and technology, for example. What's Utah State known for? Have any idea? It's satellite experiments. It's hooked up with old Thiokol, AKC, I guess it's called now. And they've got space probes coming out the gazoo. I mean, they were probably involved in this comet landing. Stanford has a wide range of things. I guess he's an adjunct professor now, but Dallin Quas, do you remember Dallin? He's around. He did his PhD in metadata analysis when he was at Stanford. Well, what is metadata analysis? That's big data analysis. I mean, that is a hot field right now, a really hot field. He also founded 2 companies that I wrote some patent applications for after he'd written his dissertation at Stanford. So it depends on what the school is. Now, as far as law schools are concerned, if you're interested in networking and you're interested in working in a particular region, look for a law school in that region. The West Coast Law School, Stanford, Hastings, Bolt Hall, Santa Clara in the Bay Area are good. Santa Clara has a very good reputation for producing technology-oriented lawyers. Stanford does general law. There are a few patent lawyers that come out of Stanford, not a lot. So you can pay a lot and end up doing something else. You can still do IP law out of Stanford, but you generally don't become a regular patent lawyer. Although my closest partner at my law firm, Dave Sloan, got his PhD in high energy physics and then went to Stanford, became the Order of the Coif, and then became a patent lawyer. It does happen. Next door is another PhD electrical engineer, Craig Largent. He was a colonel in the Air Force. The Air Force put him through school. He became an expert in lasers, and he got his graduate degree at the University of Florida. And he taught at Wright State in Dayton. But all of that really depends. You can be very selective. I went to what was considered a second-tier law school. It was Northeastern. But I chose it because it had what was called a co-op program. I worked for a year and had a year's worth of experience in patent law, and I developed basically my own curriculum for becoming a patent lawyer. And I had a year's experience before I was even hired. I interviewed at 14 firms, and I got 5 job offers. That's an incredible percentage of success. I'm very surprised. Yes?
So was that co-op like the 3rd year of law school?
No, it was every other quarter, and I got graded on what I did. Now, in a traditional law school, you spend your summers clerking someplace, but that's only 24 weeks at most where you get to clerk, and you don't get graded on it or credit for it. It's just go out and get a job. A law firm generally recruits out of their 2nd year law clerks. Other questions?
I'm still curious, so did you take the patent bar your first year, and then the next 2 years you were able to now?
I took the patent bar in the middle of my 3rd year. I passed the patent bar in November 1974, and I graduated in June 1975.
So even without taking the patent bar, you were able to do that co-op? And
Yes, the co-op was basically an apprenticeship program for patent lawyers. I had to get out and pound the pavement to try to get a job. I just went around and knocked on doors of patent law firms in downtown Boston and said, hey, I'm a student at Northeastern and I'm interested in doing a co-op quarter. Do you have room for me to come in and work for you? Want to hear some war stories? Or would you rather eat pizza? Oh, you can do both. My mentor was Bertram Rowland. Bert Rowland was known for writing the Cohen and Boyer patents on gene splicing, which is what put Stanford's technology transfer program on the map. It spawned an industry. And when I arrived there, he had written the patent applications, but he was still in the process of prosecuting them. I learned a lot from him. He had a PhD in biochemistry, so he had to actually learn bioengineering. This was an opportunity to work directly with both Cohen and Boyer, who were the co-inventors. And he spent a lot of time learning from them and then writing the patent applications. And he prosecuted a series of patent applications based on the first patent application, which spawned the whole industry related to genetic engineering. He turned over a client to me by the name of Win Kelly Swenson. Kelly Swenson was a chemist. He graduated from Berkeley, and in 1967 he came up with the concept of 3D printing. He published a provisional patent application in Denmark, where he was studying at the time, and then came back to Berkeley and worked with Bert, and then Bert turned this case over to me. And so I prosecuted a series of patent applications on a 2-photon technique for generating polymerization in 3D space, which was his technology for 3D printing. I Googled him a couple of months ago and found out that he was credited with being the first person to ever suggest 3D printing. I did a lot of patent work for HP, both writing patent applications and also analyzing some of the technology they had to deal with. And the most interesting technology of that period that I was working with HP was the Spectrum Computer Project. This was to be the successor to the HP 3000, and we wrote some, with the inventors, I wrote some patent applications on their RISC processors. They had some very clever RISC processing technologies which allowed them to synchronize the hardware. If you've dealt with computers, you know that there is some latency and actually some relativistic issues when you're dealing with very high-speed data transfer. Well, Spectrum dealt with that in some clever ways. I did work with Stanford University. Mark Gelderman, who was an MD, PhD, actually MS. He went on to get a PhD in, of all things, divinity after he received his patent and had formed Interflow Medical. And his invention was a technique for measuring blood flow by measuring mass of the blood flowing past a point using a stochastic analysis, very much like signal processing. So what he'd do is he'd heat blood in a pattern, kind of like you were exciting a radar signal, and then downstream, he'd read that pattern, and when they cross-correlated properly, he would measure the time difference between the two, knowing the distance, and he could measure blood flow very accurately. Baxter Healthcare bought that. One of the interesting stories is that some years after I'd written and filed and issued the patent, he called me up and said, I would like you to fly down to Texas tomorrow and talk to some investors. And so he put me on I got on a plane, flew down to Houston, got in a room with all of these people who quizzed me about the patent. I answered all the questions I could. That afternoon, I got on a plane and flew back to California. 40 years later, he calls me up and says, thank you for doing that, because that was the turning point of my career. So I had no idea. Well, he went on, got a PhD in divinity, and he was teaching in Germany for a while, and last I heard, he was running for Congress in Texas. Steve Chu, his laser gravimeter. Steve was very, very impressed that I was working on the project at MIT. We were going to graduate school at the same time. He was working with Arthur Shallow, and I was working with Shaul Ezekiel at MIT. Arthur Shallow, of course, got the Nobel Prize for his contribution to physics for his invention or co-invention of the laser. And Steve Chu also got a Nobel Prize, but he was very surprised that we had such an accurate narrow-band laser. And then I told him how we got the narrow-band laser. And he was very surprised. Do you know what a microscope slide cover is? You've seen a microscope. On the slide, you can put a little thin glass sheet over the top. That slide cover is very, very thin. We used a microscope slide cover as an etalon, an interferometer in the path of the laser, and we could use that to selectively tune and select out a particular vibration mode of the laser to get this very, very narrow band signal. Steve Chu's project was like 5 megahertz wide, and mine was like 50 kilohertz. So, and that was just, a mechanical contribution. That actually was the subject of my thesis. Frank Schellenberg. Frank Schellenberg got involved in an invention priority fight with IBM while he was a student at Stanford studying for his PhD. He went on to found a company, and I saw him recently. He said, I was so interested in the patent law after those discussions with IBM that you were involved in that I got interested in and became a patent agent. So he is now a practicing patent agent. He hasn't been to law school, and that's another career opportunity you have. You can become a patent agent without going to law school. You basically become a practitioner before the patent office who can't give legal advice. It is a career option. A lot of people consider that. They often work in corporations for patent attorneys. We have a number of patent agents, generally PhDs with a specialty, and there are good reasons to hire in a law firm patent agents. But it's a career which has a top end that is limited compared to being a lawyer. But nevertheless, it's a career opportunity for people with a technology background. David Deacon was another PhD student at Stanford University. So David Deacon was very interested in nonlinear optics. He had figured out how to build switches out of lithium niobate, the solid state material, and steer light without mirrors, using just by changing the index of refraction electronically. And he built a number of companies around that, and I helped him write some patent applications that became successful. SRI, there were 3 big companies that came out of SRI that I worked on. One was Communication Intelligence Corporation, which developed character recognition. They primarily focused on recognizing written Chinese characters. And they had very, very accurate Chinese character recognition. If you think about it, optical character recognition of Chinese characters is very difficult, very, very difficult. But they had figured out a technology to do it, and I helped them with their patent portfolio. Interestingly, Nuance Communication, which is the voice recognition people, used some of the similar principles of character recognition in their voice recognition technology. Nuance is actually now a merger of several of the voice recognition technologies, including Dragon, and they are a worldwide leader in voice recognition and voice technology. 2 months ago, the lead inventor, who was at SRI, who had founded Nuance Communication, a decade or 2 ago, came to me and said, I've been working with another patent attorney, they don't know what they're doing, I want to hire you. So he's back on my client list. Intuitive Surgical, I did not work with for a long time, but it is a client of the firm. Intuitive Surgical does remote surgery. They do surgery by telemetry. Very interesting technology, very successful company. Ford Aerospace became Space Systems Loral when Loral purchased it. I met Ed Radlow, he was the in-house attorney because we're both ham radio operators, and we ended up talking to each other over ham radio, and he found out I was a ham radio operator. He was in-house patent counsel there, and he needed somebody to do some of the work. And so I wrote some patents on his behalf for satellite control systems that dominated Hughes Aircraft and Lockheed. I got involved in an interference over a patent that Hughes Aircraft claimed they'd made the first invention of, and actually beat Hughes Aircraft pretty badly. They were very surprised. Global Star, you know what Iridium is? That was the satellite-based cell system that Motorola developed. Well, a competitor from that came out of Ford Aerospace called Global Star, and Ed Wiedemann was the inventor there, and I wrote his first patents. There were a number of litigations involved that I had to be a fact witness. You know, as a patent attorney, you are a fact witness to the work that you did. And so I would be called in by lawyers in what's called a deposition and sit there and be quizzed on what I remembered. So they tried to trip me up. In one such deposition, I was sufficiently astute that they had to replace the interrogator with someone more experienced because he couldn't ask questions that could get answers. It was really silly. Afterwards, the attorney representing Space Systems Loral came to me and said, Ken, I have never seen a perfect deposition testimony until now. Anyone ever hear of Paul Baran? Paul Baran is the father of Packet. He came up with the concept while he was at RAND Corporation in the late 50s that you could build a secure telecommunications network that did not communicate over circuit systems, where you would simply transmit bursts of data in packets with address headers and such over long distances over random relay stations. He ended up as a co-founder or on the board member of a number of companies, including 3Com, Packet Technologies, Telebit, Stratacom, Aloha Networks, Equatorial Communications, and Metrocom. a number of his companies were acquired by Cisco. Have you ever seen the Cisco phones that have this thing that kind of looks like a bridge, a suspension bridge on it? That's the trellis modulation systems that was invented by Paul Baran and his co-inventors when they were at Telebit. They would send very narrow band, slow signals within the bandwidth, and they developed very high-speed communication using that telecommunications technique. Equatorial Communications was one company that I did not represent. It was a time when Paul Baran was using another law firm in San Francisco, and a client of mine, British Telecom, came to me and said, we've got this patent out there on spread spectrum communication that this company called Equatorial Communications is harassing us with. Would you take a look at it? I took a look at it, looked at the claims, and says, you know, these claims are invalid. These claims assert that they are communicating below the physical noise level. And I pointed that out to them in an interference in Europe and invalidated the patent in Europe. Paul Baran came to me a couple of years later and he says, we should have hired you to write that patent. Metricom, my wife likes to say of me, I am the person who wrote the first patents on wireless digital communication. Metricom developed a system of packet communication over wireless using frequency hopping spread spectrum. They developed to be quite a company. They built a network in Salt Lake, and they built one in Silicon Valley using some micro cell sites with high-speed backhaul. And you could drive around at 60 miles an hour and communicate like you're communicating today digitally with the telephone network on their specially designed telecommunication network. They still have operations in Denver. They are a licensing agency under the name Ricochet Network, a spin-off of Metricom, but Metricom itself failed when WorldCom decided to become their sales agent. They went into a contract with WorldCom, and then WorldCom went belly up, so it's out of business. Do you have any idea why you can get large flat panel displays? The key is testing them. The test beds for those are huge granite apparatus where you can put the displays on them and they can be tested. Francois Henley at Photon Dynamics invented the technology for doing a type of capacitive imaging system where he would actually measure the capacitance of individual pixel on these large flat panel displays before they were finished, so you didn't have to test them after you'd gone through all the processing and finishing the flat panel display. He developed the test apparatus for testing flat panel displays prior to completing them, and that saved a huge amount of money in the cost of flat panel displays. Otherwise, a flat panel display really would cost $30,000 each. He also went on to found a company called Silicon Genesis, which building laminar chips. He would take bulk substrate and then laminate it with a semiconductor. I brought that company in, and one of my associates worked on it. You've heard of HD radio? HD radio is the result of a company called USA Digital Radio, which was a joint venture of Gannett, Westinghouse, and work that was provided by SRA International. Gannett came to me because they'd worked with me, or they'd heard about me doing telecommunication patents. And I wrote the earliest patents for Gannett, and they were assigned to the company USADR when they actually were formed as a new corporation. But this was in-band, on-channel, high-fidelity digital broadcasting, which is CD quality over FM, or at least over the FM band. It's not really frequency modulation. It's a form of trellis modulation that they use within the FM bandwidth's allocation. Their whole goal was, we don't want to give up our licensing franchise in the channels that we have. We wanted to be able to use our existing stations and licenses and still provide the high-quality broadcast. They also developed it for AM. Their competing technology was Eureka in Europe. But Eureka was basically a centrally managed telecommunication system where the government set up all the transmitters, so they didn't have to worry about how stations were allocated. Next computer. Steve Jobs didn't hire me because he couldn't control me. And I thought that was a great compliment. I didn't feel bad about that at all. I do have a number of Utah connections. As I mentioned, Dallin Quas founded Jungly and Whizbang Labs. I wrote patent applications for him. I did patents for YCAT and a couple of BYU professors. and Switchpoint Networks, which tried to put networks in the backyard on cable, and they'd come up with some technology so they could do some broadband communication via coax in the neighborhoods, and I think they're out of business now. Russian connections. This is the other company that I did patent work for. Paragraph International had used some Russian scientists and mathematicians to come up with some character recognition technology. This character recognition technology was incorporated into the first Apple Newton, the predecessor to your iPhone and iPad. The problem with it was that the resolution in the Newton was so bad that it couldn't recognize anything.
Yeah.
It was a huge flop. In fact, when I wrote some patent applications on, I ended up doing some prosecution, and I used a cartoon about how bad the Apple Newton was as part of the arguments in favor of the patentability of the paragraph technology. I patented the first digital hearing aid. I wear a digital hearing aid that's based on the technology I patented in 1980. It got involved years later in a patent fight with Resound. Resound tried to argue that their technology was not covered by the claims of the Anderson and Lloyd hearing aid patent that came out of Jared Anderson. I was a fact witness on that case, and in a very unusual procedure, the federal district court judge found the patent valid on the face of it, and the only thing that went to trial was whether or not the patent was infringed by Resound. I was the first witness. I was cross-examined by the lawyer for Resound after I'd presented the patent and shown the beautiful blue ribbon document that is the letters patent. And the lawyer for A&L got up and asked me a question. He said, "Did you ever meet anybody from Resound?" And I said, "Oh yeah, here are my notes. I told them about this very patent several years ago, but they didn't hire me." You should have seen the defense attorney jump up. We had nailed him. The jury
Well,
found
that qualifies them for treble damages or
that
something?
it qualified them for treble damages, and they settled for treble damage. The other patent that Jared Anderson worked on was the real chip. This was a way to simulate a device by actually using the device in the simulation library. You'd actually plug in the device into the board and use it in a simulation system. We got a patent on that. And the way they did that, where you had to deal with a dynamic clock, was to clock it and then advance it one clock position and then clock it again. So they could build a profile of the operation of the system at the speed that the simulator was working at. Very clever patent. VSAT systems, I worked for Viasat, and we wrote some patents for VSAT systems, which are now dominating the KU band. My clients today are the Chinese University of Hong Kong, Complete Genomics, and Solar Junction. Solar Junction has, if you can believe it, solar cells with proficiencies in excess of 40%. Normal solar cells that you see every day have an efficiency of like 3 to 5%. They do it with some very interesting band gap engineering. Complete Genomics, as I said, is the fastest genome sequencing technology in the world, and the Chinese University of Hong Kong is doing a huge amount of work in efficient use of digital networking, particularly for delivery of multicast digital television.
Right.
When I got started in patent law in 1975, it was a total backwater practice. Patents were ignored, they were not enforced, there was a patent consortium involving AT&T, and they were just generally ignored. But in 1982, the Court of Appeals of the Federal Circuit was formed out of the CCPA, the Court of Customs and Patent Appeals, and it became the court of last resort for patents. And then that created a sense of consistency among and across all the patent cases that were up in the courts. Patent law became a desirable career. Patents became valuable assets. And then we've had some spin-offs that are probably not so favorable. The so-called non-practicing entities have tried to package and monetize patents that otherwise wouldn't have been monetized, and causing people like Mitch Kapoor to have conniptions because he doesn't like to be constrained by patents. But nevertheless, patents do promote the progress of the useful arts, as it says in the U.S. Constitution. I'll tell you one last story about AT&T. I was representing Nokia against AT&T in some licensing negotiations back in New Jersey. My colleague was explaining to AT&T why AT&T's patent portfolio that they were trying to get Nokia to license should be ignored as far as Nokia was concerned. We had gone through all of these patents, which happened to be on cryptography, and explained that the claims were not sufficiently relevant to what Nokia's technology was, that they didn't have to pay a license. Well, the AT&T lawyers threw up their hands in frustration. We were in a conference room about this size with a table like this. We had our backs against the window, and they were over there, and there was a big wall. On the wall was the copy of the original letters patent to Alexander Graham Bell for the telephone. The lead negotiator for AT&T threw up his hands in frustration and said, "You should take a license. After all, that's our patent." And I told him, "Yes, that's your patent, but it expired 100 years ago. We're free to practice anything that doesn't infringe a valid patent that is in force." So, with that, I thank you for your patience in listening to me. I hope that you will consider some of the options you can pursue as technologists, as engineers, and maybe even lawyers or patent agents someday. Any other questions? Yes?
As far as like your undergrad, does it matter how much, like which classes or what your kind of focus is as far as an undergrad? In relation to your career?
I think you should have a good creative writing class. One of the things I do is I actually write short stories. It actually helps you become a persuasive writer, to think about the tools that are available to you as a writer. But as far as technology is concerned, narrow and deep is probably better than broad and shallow. If you get into a technology which is hot, and as I said, biomathematics is the hot field as far as I'm concerned right now, you can become very valuable in your area. If you want to remain flexible, you get lots of coursework, at least get exposed to it so that you become fluent in the vocabulary of it. Somebody asked me once what was the difference between a Harvard education and an MIT education. Well, at MIT you learn more and more about less and less until you know everything about nothing. But at Harvard you learn less and less about more and more until you know nothing about everything. I hope that answers your question.
Well, thank you, Ken. I really appreciate you coming out and making time for this. I just wanted to point out one thing. I don't know if you guys heard a couple of years ago, law school enrollments were tanking about 3 years ago because the country was overproducing lawyers. And in fact, at BYU, they were offering people scholarships to the BYU law program that wouldn't even have been admitted 2 years prior to that. That's how woeful the state of everything got. But in spite of all of that, during that entire period, it's starting to pick up now again, but during that entire period, there was basically one field in law that never dipped down and where the nation was still underproducing for demand, and that was IP law and patent law. There's incredibly strong demand out there, but there are very few unemployed, qualified IP attorneys out there.
That's true. That's true. In fact, it's a very interesting statistic. About 4 years after a big burst of the technology bubble, we see the most qualified patent lawyers come through the law schools because their careers have collapsed, so they go to law school. And then they come out and we hire them. They're great, great engineers. I graduated second in my engineering class here at BYU. I came out of BYU, there were 0 jobs. So I went to graduate school. There was one job when I got out of graduate school. I had a choice of HP or law school, and I chose law school.
Now that situation has changed, though. There's plenty of jobs out there for you guys.
Yeah.
Don't go to law school, too.
So don't go to law school yet, but keep it in mind. Keep it in mind. There's an option for you, particularly if you're bored with engineering. Or if you like engineering and find that you're becoming obsolete. Because you can go back, you can study some more, you can go to law school, you can go to business school, found a company. My son, he's founded a company. He makes screen spiffers. Screen spiffers are microfiber patches that he puts on the tongue of ties and is used to clean smartphones. He and his partner have a patent on that.
Did you write it?
Of course. I also wrote his most famous patent. When he was 14 years old, he saw an article in the New York Times about a guy who got a patent for using a laser pointer to exercise a cat. And he said, that's silly, I could do something better than that. And I said, okay, you build something, you write something up, and I'll write a patent application for you. So he took some Legos, and with the motor in it, put a shaft, put a laser pointer on top of the vertical shaft, aimed it down, put it in the middle of the floor, turned on the motor, and the laser pointer spun around, and the cat chased it. We wrote a patent application on this mechanism for exercising a cat automatically.
Has it ever been licensed?
It was not licensed, but it did get cited to the Supreme Court as an example of a silly patent. When he hands out his resume, he puts his patent number on it, and everybody looks it up. One day I did get a telephone call from a reporter saying, I found this patent that was cited in this case, the Bilski case, all about the patentability of software. And they said, there was this patent in there by a Keith Allen, and the only Keith Allen I could find was a high school student in Palo Alto. Do you know anything about this? And I said, sure, that's my son. And he did that when he was 14 years old.
Excellent. Well, thank you very much, Ken. We appreciate it.
Thank you.